Thank you, Elizabeth, and good afternoon, colleagues. So my name, as Elizabeth said, is Sukhninder Panesar, and I'm a senior lecturer at the University of Worcester Law School, having previously held management positions and other institutions as well. So I've been teaching property and equity and trusts for now 33 years. This is my 34th cohort of equity and trust students. And what I wanted to do today in this webinar is to explain a little bit about my journey as a student studying equity and trust, some of the challenges I found as a student studying equity and trust, and then moving on to go on to teach equity and trusts relatively quickly after graduation, having been thrown in the deep end by my head of school then, who asked me after graduation, what would you like to teach, as I was going on to do my master's. And I said, I'd like to teach some contract law, maybe some tort or crime. But he landed on my desk equity and trust. So I was literally thrown in the deep end, having just come out of law school. I want to talk about some of the challenges that tutors across the sector face in teaching equity and trusts. Particularly when we look at it from the context of the lived experience of our modern students, our contemporary students studying equity and trust. We'll then move on to looking at some of the key features of the 5th edition of Revel, and particularly how the book and how I see and why I wrote the book the way in which the book is written. And we'll look a bit about the importance of context and application and critical analysis. And I know this has always been a key issue for tutors when it comes to learning outcomes of a module, where we have to address, learning outcomes at level 5 and level 6 when we're looking at things like critical analysis, application, and understanding the context in which the law has been developed in equity and trust. And then we'll move on to some of the particular features that we've incorporated in this book, in the 5th edition, the online version of Revel, some of the aspects of practice points, seminar questions, and moot points, which then, packaged all together, allow the students to have, an enjoyable experience studying equity and trusts. So if I just move to the next slide, if I can. Just bear with me. Yeah, so when I first started teaching equity and trust as a tutor way back in 1991, I sort of reflected on my own journey as a student relatively quickly. And I started to think about, the challenges I faced and how I could, use my own experience in understanding what I found challenging and how I could help future students studying the subject to see the subject as an enjoyable experience and one that they could possibly relate to. So as you can see on this slide here, I was, a first generation of student to go to university in my family. My parents had come from the Punjab, and my mum lived in Tanzania, and they moved here in the 1960s. And we grew up sort of like in the 70s, four of us, four children, went to state school, state primary school, state secondary school, and had a typical 1970s and 1980s education with the challenges that brought at that period of time. But I was very pleased that I did get an opportunity to go to what was then Lanchester Polytechnic in 1988 to study business law. And immediately going to university was an experience that I couldn't relate with anyone in my family, because nobody had been to university. And I know this is something that lots of colleagues in the sector will equate to, a first generation of people to go to university. So I arrived at law school, and my first year was pretty much a very interesting year. We learned lots of ideas and concepts about the law, where the law comes from, where the law is practiced. We learned some contract law. We learned elements of public law. Contract law, I sort of got the idea, the concept of a contract, a person entering into a contractual arrangement. somebody goes into a newspaper shop, buys a newspaper, they've entered into a contract. It's only until the second and third year that I started to face a number of challenges. And those challenges were when I was introduced to terms where the expectation on me was that I would possibly know what these concepts were without much explanation from the tutor. And I distinctively remember, and I still share this with my students today, we didn't have any PowerPoint slides. And I remember my tutor, a fantastic tutor, however, put on what was then a blackboard, a statement where the lecture started off with this statement, as you can see here. We're going to be looking at today a transfer of Blackacre in fee simple absolute in possession, which will take place within the perpetuity period of a life in being plus 21 years. Now, I'm sitting at my lecture desk, whatever, in my seat, and I'm wondering, what does this sentence actually mean? Because if you look at my kind of context and where I've come from on my journey so far, the concept of Blackacre wasn't very clear to me. You know, the tutor talked about Blackacre, the transfer of Whiteacre, a fee simple absolute in possession within the perpetuity period. Now, I looked at this and I thought, how do I relate to this? It only became apparent after a couple of weeks, and I had to make the effort to ask the tutor, what are we dealing with here when we're dealing with a transfer of Blackacre? To be only told, and that this is a reference to a piece of land that is being transferred, the freehold title, and there is this concept of the perpetuity period. And sometimes very little context was given as to what was being said and why it was being said, and how I would then sort of understand where the direction of the law was traveling. Now, this is just one of many examples where I sort of felt that I wasn't included. I wasn't included in the kind of the learning process. There wasn't much inclusivity here. So that's just some food for thought that I really wanted to reflect on. And I thought it's really important that context is really understood by our students and modern students who are studying, you know, areas like property law and in particular equity and trusts. So what are the challenges facing tutors teaching equity and trusts in modern law schools today? Well, I think these 3 points really do sort of like give it away. I think, you know, as the first point there says, ask anyone who studied law which topic they found particularly tricky under their undergraduate degree. And I think you can more or less put money on it that it's going to be equity and trusts and property law, equity and trust being featured. Well, I didn't understand equity and trust. What was all that in equity and trust? It was very difficult. And I think it's fair to say, and I think one of the things we have to accept, that it is a notoriously difficult area of English law, and students are often filled with trepidation before they even start the module. You know, I get second year students, you know, when they've finished their second year and they're dreading that final year where equity is often taught at level 6. We've got this really complex core module next year, and how are we possibly going to understand what is going on here? And I asked the question, so why is this the case? Why is this the case? And I think there are a number of reasons for this. I've identified 2 reasons why the law is very complicated here. I think it's fair to say students tend to have little by way of a general inclination of the subject matter of equity compared to other areas. So if you look at criminal law and contract law, and I was speaking to some of my colleagues at Worcester Law School only last week when we were talking about this webinar, and I share an office with a criminal lawyer. And, you know, she was saying, of course, Sukhninder, when it comes to criminal law, the students will sort of relate to the criminal law from what they hear in the news. When they hear concepts such as murder, manslaughter, gross negligence manslaughter, theft, the students generally will sort of like, you know, want to study criminal law because they see that as an area they want to practice in. And I think the same applies to a number of other areas of law. Contract law, I wouldn't say contract law is by any means an easy subject, but at least the students will understand where the law is coming from and what basically the law is trying to deal with, which is basically govern the relationship between people entering into agreements. Now, that's not necessarily the case when it comes to equity and trust, because the students will have very little by way of understanding of what equity is, and indeed what a trust is, and why a person may want to enter into a trust situation. And I've also identified in the course of my teaching this subject over the number of years I've taught it, the subject matter it's by its very nature broad and complex, because the trust concept and equity sort of pervades across the English legal system. So you've got elements of the common law, contract law, tort law, criminal law, but equity, pervades right the way across those areas of English law. And in particularly when it comes to the trust has operated in a number of wide, diverse contexts, including family contexts and commercial contexts. So the breadth of the subject matter is quite extensive, and trying to get your head around the whole breadth of it can be a very challenging and daunting experience for the students. So, as I've put here, it's daunting, but what I wanted to do from the outset, from my early days as a tutor teaching equity and trust, was to start thinking about how we develop and how we teach equity and trust in a way that doesn't hamper the students' complexity, but how we can support that complexity, and how we can actually make students understand that, equity and the trust concept has been a very important part of English law, particularly in engineering, social and economic reform. When students start understanding how equity is operated and where the trust is operated, and the elaborate nature of these two concepts, the students then get to understand things like social reform, look at economic reform. We were discussing this with my students only last week, where we had our early seminars on what is equity and why do we need equity in our English legal system. And as soon as students start to see what equity does and how it operates, they start to understand the rights of married women, and how rights of married women were protected, the rights of illegitimate children. If you look at more contemporary focus of equity and trust, particularly in areas such as non-marital cohabitation, how equity is sought to play a very important part in engineering social reform there. We look at sort of like economic reform and how equity has operated in very complex commercial settings, but with a view to actually producing results which have been engineering kind of economic reform moving forward. So I think this is where I start my journey, and this is where I started my journey in writing what was then in 2010 the first edition of Equity and Trust by Pearson, and now in its fifth edition. What I've done in this book is, in order to aid the effective understanding, and I know lots of other textbooks in the sector have also sought to do this, one of the things I've attempted to do in order to address the complexity of equity and trust is to divide the book into 5 main compartments. So the students are clear from the outset, rather than looking at this as a heavy, daunting 23 chapters looking at all sorts of areas of equity and trust, is firstly to clearly figure in the student's mind that equity and trust, in order to have an effective understanding of equity and trust, we basically put this area of law into 5 compartments, if you like. And I think once you start doing that, the subject matter becomes a lot more accessible. So firstly, we introduce students to equity and trusts. What is the whole purpose of equity? What is equity doing in the English legal system? And what role does it have to play? How does it operate? What are the maxims of equity? And what does modern equity look like? And I think that's one of the key things that I am attempting to do with my students and attempting to do in the book. What does modern equity look like? We have lots of historical kind of things to say about equity from its original development from the Court of Chancery, and even before the Court of Chancery, the ecclesiastic courts, and the development through the medieval period up until we have the 1800s and 1900s. But what does modern equity mean to a student? And I think that really is important, having that context. I'm not saying historical factors are irrelevant. I think historical factors have shaped the law, but I think where we are now in the 21st century, what is modern equity attempting to do, and what does it look like? And I'll probably say a little bit more of that in a subsequent slide about students' perceptions of equity. And then, of course, what is the trust doing? Okay, so as for some of you who have used the book or have seen the book, what we do is in the very first part of that book, in the second chapter, I believe, we position the trust in terms of its contemporary importance, and in a way that we sort of put the students in the picture. So we sort of start telling the students, why may a student think about equity and trust, and why may that individual actually create a trust? So we start using names, we start identifying people, and we start giving lots of examples. And my approach to this is not just to define the trust, but seek to actually look at its application. So for those of you who have used the book, I tend to use the word suppose Jasmine and Ashraf were going to do this. Suppose Peter and Michael were going to do this. And it's the suppose question which then really gets the students to think about, okay, I can see why A, B, or C may want to do this. So how, therefore, does the trust become an integral part, or how does the trust become a vehicle by which the purpose can be achieved? And I think once you start attempting to do that, the students start understanding the context. And I think the context is very important. What is the contextual reason why we have the trust in our modern day kind of like social and economic business relations? And I think students will then quickly latch on and say, well, I can get this now, just like I understand my criminal law, just like I understood my contract law. And too often, as I said from my own experience, it was very difficult for me in my early days, in my first 6 to 8 weeks, even my first semester of studying equity and trust, trying to understand, why are we doing this? Because the textbooks were quite dense, and they talked about historical factors, gave some very historical reasons why the Earl of Chesterfield or why the Earl of Dartmouth might have created a trust in the year 1700 and something. But I think this is really important. So once the students understand the substantive reasons why people create trusts and the concept of modern equity as positioned in its contemporary form, we can then ask the students to say, we'll now move on to looking at how we create the trust relationship. Okay, so how do you create a trust? In the same way the students would have learned in their first year, how do we create a contract? What are the requisite requirements of forming a contract? And students generally will have very good understanding of, concepts like offer and acceptance, consideration, intention to create legal relationships. The same doesn't often really come through when it comes to trust law, but what we do in the book here, from the outset, we clearly elaborate what is required for the creation of trust. So what is the substantive and formal requirements for the creation of a trust? Once you can put that in its context, the study of the following topics, like the formalities and the constitution of a trust, the three certainties, becomes a much more kind of like clear kind of progression for the students, because they can see that we are creating the trust relationship. And in doing so, this is why these subsequent chapters become very important. We then, of course, cannot ignore those trusts which are implied by the law, and we start to think about why the law needs to imply trusts. Okay, so what is the theoretical basis for the imposition, for example, of an implied resulting trust or an implied constructive trust? So again, I remember my own experience as a student. We were introduced to a resulting trust, and we were given lots of examples of a resulting trust. I remember we started looking at constructive trust. But again, what we attempt to do in this part of the book is to look at the theoretical basis for the implication. Why is the law implying a trust? Why is the law implying a constructive trust? And what is that process of implication? So whereas students will have seen in their previous studies, in their first 8 chapters, that the creation of an express trust is created, and it's looking outward. It's looking outward looking, where you're saying Sukhninder is creating a trust for his son on him attaining the age of 21 years. And whereas an implied trust is normally looking at conduct that has possibly taken place in the past. And what the court is trying to do is to look at previous conduct and attempt to identify whether in that previous conduct and the facts which are presented to a court, there is a trust which needs to be imposed there, because not to do so would result in some underlying unconscionability. Again, the students will then start to relate to this and start getting a very clear distinction between an implied and an express trust. We then, in chapters, fourth part of the book, in the subsequent chapters after implied trust, we now go back to our students and we say to our students, we clearly have a trust for whoever, and now we then look at the administration of the trust. So what is the role of the trustees? What can a trustee do and what can't a trustee do? What is the nature of a trustee? What kind of obligations do they have? What duties do they have? And of course, a key part of this part of the law is the maladministration of trusts. So we start looking at some more contemporary areas, and I think the focus becomes much more on sort of like contemporary administration of trusts, and looking at remedies for breach of trust, whether they be personal remedies or proprietary remedies. And that in itself being a contained area of law, again, the students can understand the context. And last but not least, we introduce students to charities and charitable trusts. So by this time of their studies, the students will clearly be aware of the distinction between private and public trusts. So we look at charities and charitable trusts and see how the law has developed in terms of contemporary cases on these areas. So what I also wanted to talk about today in this webinar is the students' perception of equity and equitable jurisdiction. And one of the things I'm very keen to do at the outset in my book is to dispel the students' perceptions that equity is about fairness and justice. And because one of the things that the students do often come into, and I certainly have seen it over the last 30 odd years, 30 plus years, you know, when you ask students, what is equity and what does equity do? And, you know, inevitably students will talk about the concept of fairness. And that sort of comes from their previous perceptions of what they've seen in the areas of common law. Equity is to do with fairness and justice. And I want to dispel this from the outset, absolutely make it clear that whilst all law, whether it's common law, statutory law, or equity, would have a broad concept of fairness and justice, equity is not, and certainly modern equity is not based on this broad concept of fairness. I mean, yes, our students will get to know historically the position of equity was to iron out the deficiencies of the common law, but modern equity is based on established doctrine and principle, which is not based on broad concepts of fairness, but the underlying reason why equitable jurisdiction is asserted by the courts is based on the unconscionable conduct of a defendant. And it's the underlying unconscionability to be distinguished from the broad concept of fairness that invokes an equitable response or an equitable remedy in any given set of circumstances. So sometimes I have many students asking me, well, equity will iron out the deficiencies of the common law. And if the common law isn't right, equity will do justice and bring about a fair result. Again, we want to move away from those kind of perceptions about fairness. I've had a very interesting seminar question last week with one of my students, and one of my students asked, she said, that's all very well, Sukhninder, but how do you define unconscionability? because again, unconscionable conduct, again, what is the definition? I mean, you can't just say equity operates on unconscionability. So what I've done in the first 3 or 4 chapters, and certainly in the first chapter, is to get the students to think about what is unconscionability and what is unconscionable conduct. And the students will soon seek to get an understanding that unconscionability and unconscionable conduct is based on a clear set of principles, depending on what context is being argued in court. And inevitably, you can say equities probably become as rigid as the common law, because in order to invoke unconscionability, you need to have to prove to a court of law a set of defined principles depending on the context you're talking about. So my students already in week 6 of my equity and trust classes, when you ask them about unconscionability, they will say, for example, unconscionability, when applied in the context of proprietary estoppel, requires a defined set of principles to be proved to a court of equity, the assurance, the reliance, and so forth. If you look at the imposition of a common intention constructive trust, that is based on a defined set of principles which must be proved to a court. If you're looking at liability for knowing receipt and knowing assistance, again, the underlying conscionability has to be proved. So that is rather different from this broad concept of fairness. And as soon as students get to understand that, their understanding becomes a much more effective. So I think that's one of the key things I really do labor on at the outset of the book. So if we start looking at some of the key features of the book, and I know in the course of teaching this subject for a long period of time, and alluding to some of the things I've already said at the outset of this webinar, I reflected on my own journey as a student studying law at law school in 1988. I think the importance of context is very important, and no more is that the case when it comes to teaching equity and trust. What is the context? So what I do in every chapter in this book, and certainly in the 5th edition, as in previous editions, is every chapter starts out with what I describe as setting the scene. So I am very reluctant to open a chapter and go straight into the technical rules of that chapter heading. So as you can see here in front of you, this is chapter 8, and this is a chapter on purpose trusts and the beneficiary principle. And what we do in this chapter, like we've done in the previous chapter, is to actually explain why we're looking at this concept of a purpose trust and what is the importance of this so-called beneficiary principle. Now, I do that by looking at a particular case that they will have to study when they are reading this book. So let's just look at this example here. So we've got a case of Reaster Settlement Trust. So those of us who teach equity and trust, we know that this was a case decided in 1952 where the settlement was to create a trust to preserve the independence of the Observer newspaper, and there was other kind of conditions in the trust to promote peace in the world and so forth, coming out of the Second World War. This is where the context of the trust comes into being. So this is what I want to do, and I give them this case, and then I basically put there, as you can see in the third paragraph of setting the scene. So I put Reaster Settlement Trust raises an interesting question for this chapter to address, and whether a trust can be created for a purpose. So the purpose being to promote the independence of the newspapers and peace in the world. I asked the students, this is what the context of the trust is, and why did this case go to court? Now, additionally, what I also do is then to think of more modern examples to make the students' interest in the chapter even greater. So I then introduce to the students, and equity is a dry subject. It's very difficult to teach sometimes to get the students' attention. But we then look at a very interesting newspaper article, which was in the Financial Times, where philanthropy goes to the dogs. And I raised the question, can I leave my entire estate to my 2 cats, Molly and Polly, to which my student audience, grin and laugh at me and think, what is this man saying? How can you possibly leave, your entire estate to your 2 cats? Well, this is exactly what I said happened in a case in the United States. As soon as you start bringing this context, the students is getting more and more focused, and the student wants to say, well, tell me more then. Tell me more what's going on. I think that really is important. And I think that's where the book has really helped a lot of my students over the years to start understanding the importance of context. Very important. So in addition to the importance of context, and I'll come back to this in the next slide, is also reflecting and paying emphasis on the student's lived experience. So what I want to do when I teach equity and trust, and what I want to do when I write about equity and trust, is to think about who is my audience? Where have my students come from? Are they a first generation of students who are coming to university? Are they students who are coming into university at a later time in life, mature students? So what kind of students have I got? Okay, I'm looking at all the kind of students and their lived experience. What have they experienced in life? And how am I going to relate this equity and trust to them? And I think this is a debate that is happening across higher education, across the sector, not just in English higher education, but across the globe. How do we sort of make our learning experience a much more inclusive learning experience? I know there's lots of debates now on decolonization of law school curriculums, and we again are looking at that. And how do we make our law applicable to where the students have come from, and how do we make their learning a much more inclusive one? Now, this can be really challenging when it comes to equity and trusts, because a lot of the cases they will look at will be cases where we're dealing with individuals with high levels of wealth. They will not necessarily know why a person would want to create a trust. What are the advantages from a tax point of view of having a discretionary trust? They won't relate to that. What are the rules in the Howe and the Earl of Dartmouth and the Earl of Chesterfield? How do these apply in modern contemporary trusts? What I'm not saying to my audience is that these trusts are not relevant, or that we shouldn't emphasize these. All I'm saying to my students is, let's contextualize this. Let's start looking at your lived experience. Of course, you may not have had a trust, because the circumstances may not have given rise for you to have a trust, but to put the students at the heart of every example you give. And it goes back to my suppose Jasmine and Ashraf were living together. Suppose this happened. Suppose that happened. What would equity's response be? And I think that kind of contemporary inclusive approach is a much more rich experience of learning equity and trust. And certainly from the one I had, and I'm not being critical of my tutors, I really enjoyed my days at law school, but it was really understanding context. I'm coming back to my accommodation and I'm picking up my equity and trust notes, and I'm wondering, why have I got this case of Earl and the Howe and the Earl of Dartmouth? Why have I got Earl of Chesterfield? What was going on? What exactly were we dealing with these individuals? What kind of wealth were they holding? I need to start understanding that context. So I think that's really important. And then we move on to the next important feature. So that's 5th edition of Revel online, is emphasis on application of the law. And I think this again is really, really crucial feature of the book. So what we're doing with emphasis on application of the law is, as well as having set the scene at the outset of the chapter, throughout the chapter, I am asking questions to the students. Because before I want to talk about a particular rule of equity, I need to tell my students, why am I going to teach you this rule? I'm not going to teach you this rule with no context. So why am I teaching you a particular rule? So everyone in this webinar who teaches equity and trust, and I'm assuming you do teach equity and trust, and this is one of the reasons you're here. I mean, I could talk about the certainty requirements for the creation of a fixed trust, and I could write quite a lot on the decision of the court in the Inland Revenue Commissioners and Broadway Cottages. I can talk about this fixed list test. and we can talk lots about conceptual certainty, evidential certainty, and the story goes on. We all know what the law is. But I'm actually want my students to understand, before I even talk about a particular principle of law, why am I actually talking about it, and why would it become relevant, and where would it be applicable? So this is just one of thousands of examples in the book. So we've got here applying the law. So you've got, in an inter vivos deed executed last year, Chris transferred a sum of £200,000 to his trustees to distribute at their discretion amongst his relatives, best friends, dependents, and any other such persons with whom he had a close connection. So do you think this creates a valid discretionary trust? So I want my students to think about, one, that this is a discretionary trust because the trustees have got a discretion. But potentially, I want my students to see what the problem is before I tell them what the law is. And I ask them what the problem is. And we start, obviously, entertaining questions of conceptual uncertainty. Maybe the words dependence and best friends may cause some issues to the trust. Once they've understood that and they say, oh, Sukhninder, I get it. I can see some problems with this trust. So what I want then for my students to do is then to think about, well, how will the law address this, and what are the rules of the law? And then subsequently the law will then follow in that situation. So we're almost there. So I think, and I certainly over the last 34 years, have really enjoyed teaching equity and trust. I think it's such a rewarding area of English law to teach. It's rewarding for a number of reasons. One, the fact that you are able to add value to the lives of the students from a subject that is particularly complex, but that you can actually make it and they understand it. And one of the most rewarding parts of my teaching is when students actually come up to me at the end of a class or at the end of a module and say, you know what, that was a really complex area of law. And I really got that. I really got the perpetuity rules. And you don't get people saying that too often. I got those rules today. I can see where they come from. They're historical, economic kind of like reasons for creation. Now, the book has moved on significantly from the first edition. And one of the things what we're doing here at Pearson, and particularly in the Revel series, is the additional features that you will have in the book, which is not just the substantive law as stated, but all the things I've already talked about: setting the scene, application of the law. You've already got the ready-made seminar questions in there for you to use if you so wish to use them. There are mock questions in there for those students who want to get those higher level of marks, where we're asking them to concentrate on critical analysis and so forth. And also, whilst I would not hold my hand up and say I'm writing a book for the purposes of the solicitor's qualifying examination, I don't have that experience. But what we have incorporated in this book is some element of practice points where the students can concentrate or apply the law and get instant feedback. And what you can do as tutors using this book is to use it in a way that suits your particular needs. There are performance dashboards where you can identify student progress, identify those who have not completed assignments. You can use the assignments that come with it. And basically, it allows you to actually give students instant feedback, or for the students to get instant feedback and understand where they are going and the direction of travel. So I think I'm going to conclude it there. I've used 14 minutes of my webinar. So those are some of my experiences, some of the ways in which I really have enjoyed teaching equity and trust. I continue to do that at Worcester Law School, where we're very much, looking at students' inclusivity, helping our students to learn, and, adding value to their lives. So thank you very much. So I'll hand back to Beth for any questions.
Thank you, Sukhninder. Yes, we have some pre-submitted questions, so maybe we could cover them now, if you don't mind. So, but the first one is, for those of us still teaching in hybrid model, how do you suggest we ensure inclusion of students online and in class?
Yeah, a very good question. And I think the book is very much supporting hybrid learning, because one of its availability, it's obviously available online, and the students can dip in, dip out of areas that they want to look into. But particularly when it comes to hybrid learning, in terms of feedback, assessment, looking at students who can remotely engage with material, I think the platform, the performance dashboard platform, provides tutors with excellent opportunity for their students to do particular exercises which may not necessarily be require in-class attendance. So I think the book is very much supportive of that kind of learning.
Thank you. I just would like to encourage everyone, if you have any questions, just please either type them into the chat or raise your hand, and I will allow you to come off mute. Second question. A learning outcome for modules such as equity and trust, which are typically taught in year 2 or 3, is for students to understand the context of the law and how the law works in practice. How do you suggest we cover this outcome in modules?
Yeah, so if you look at module learning outcomes for equity and trust, and indeed any module in our law school curriculums, our learning outcomes, obviously depending on where you are, levels 5, 6 or level 4, we will talk about the need for students to understand equity and trust in its modern day context. That's particularly an important learning outcome. We have learning outcomes which say students should be able to apply the law and critically evaluate the law. So I hope I've sort of answered that in the webinar, because what we're doing in the book is making those learning outcomes very, very clear to the students by asking those questions. This is the context of why you are studying a particular chapter. So if, for example, a learning outcome at Law School X says, on module equity and trust, students must understand the contemporary context in which equity and trust operates, you will get this from the book because the context is clearly articulated. Students must critically evaluate the law. Students must apply the law. Well, I've given many examples of application of the law. The book obviously also caters for the students who are seeking to get those higher level of marks, where there is need for critical analysis. So if you look at the end of every chapter, there is quite an extensive range of reading that the students will be directed to, as well as I put moot questions, critically evaluate whether the decision in case X was justified in light of. One of the things we were talking about, and certainly a lot of law schools are talking about, and I know at the start of this webinar, we were talking about artificial intelligence and the direction of artificial intelligence. I mean, we need to be careful how students use artificial intelligence and the credibility of artificial intelligence. What I want to do, and I have done in this book, is to direct them to sources of law, journal articles, which will aid their understanding, which will sort of give them an indication of the kind of things they want to do. So in terms of answering the question, the book does do that. It talks about context, it talks about critical analysis, it talks about application. So it therefore aids those learning outcomes on a particular module, specimen, template, as they're often called.
Thank you. I cannot see any hands raised, but I have some more questions for you, so pre-submitted ones. So how do you ensure that your time with students has maximum impact?
Well, I think my time with the students in terms of maximum impact is, one, I need to understand my students and where they are. I need to understand what they've learned and where they are finding things difficult. I, like my colleagues at Worcester Law School, create a very inclusive learning environment. We want students to raise questions. I want to know how they're doing. There's a lot of emphasis on formative assessment. And once I can understand which particular students are doing okay, which ones need more support, I'm there to offer it. And I just think making that learning experience in classroom a really enjoyable one, that is really, going to say we can ask a question without fear of any question being a stupid question or a silly question. And I think also, make equity and trust fun. It can be a fun, experience with the examples you give. And I think that's how I maximize student kind of experience and students, value added to what they're doing.
Thank you. There's one question in the chat. Do you use pictorial resources at all?
Yes. So one of the things I do a lot for anyone who's seen me teaching is in my lecture PowerPoint slides. They're not dense text. So we will get an example of, so one of the things we've been looking at recently, a case, a complicated case which cuts across trust law and company law, Preston Petrodel, a very complex case in the Supreme Court. I'm giving some context to Prest, who Mr. Prest is and who Mrs. Prest is, why they find themselves in a divorce, what was happening in Nigeria with petrol industry, what was happening with the Matrimonial Causes Act, because this case cuts across family law. And I know some of my colleagues who are joined in this webinar today will also look at that from that perspective. So I think it's very important. And I think the one that students really struggle with is a case called Vandervelde and the Inland Revenue Commissioners, a very complex set of tax law cases. Now, I absolutely did not understand Vandervelde when I was a student. I don't know how I passed my equity interest exam, but I did just about. But Vandervelde, I situate Vandervelde. My opening sentence when I introduced the case of Vandervelde, I introduced Lewis Hamilton, and they look at me and say, "Why are you talking about Lewis Hamilton? Isn't he a Formula One racing driver and who's won the title 7 times?" And after all that, they're really intrigued as why I've introduced him. Well, I say Vandervelde, same sort of facts, Formula One. So these pictures, kind of like pictorial, help them to understand what is happening in the cases. And the other thing I very much use is short summaries of the Supreme Court cases where Lord Sumption or whoever the Supreme Court judge was sums up the case in about 7 or 8 minutes, and they see real time after having explained the law. They go, "Wow, I understand that judgment now. After what you've told me, Sukhninder, it makes sense."
Thank you. Well, Alicia O'Brien sent you a message that I have a class on Vandervelde tomorrow if you would like to hop along.
I love teaching Vandervelde. I know that sounds really strange thing to say, but if you situate Vandervelde and bring Lewis Hamilton into it, you'll get their attention.
All right, so maybe 2 more questions can fit in our time. One is, what are your top tips to increase student engagement in law?
Well, the top tips to engage student in equity and trust or in any subject is to, as I say, all the things I've understood is to understand context. Why are we actually here for the next 2 hours? And sometimes when I was a student, I couldn't understand why I was sitting in the classroom, other than there was lots of rules being, being told to me. So why are we doing this? How does this all relate to the assessment? Because that's ultimately what students will be interested in. So why are we here today? How will today's lecture and how will today's seminar support you in the forthcoming assessments? And how can you use these sessions to get the best outcomes? Because that's what they are interested in. And how then beyond the law degree will this become relevant to you? So I think that's really important.
Right, thank you. And if nobody else has any more questions, I mean, we still have time for that, but maybe okay. One more question, sorry. And it's about your memorable teaching moment. What is your most important or most memorable teaching moment, and why?
I've got so many memorable teaching moments. I think the one that strikes out the most for me, it goes back to, was it Brian who said something about Vandervelde? I remember teaching the decision of the court in what was the second of 2 cases on Vandervelde number 2, where I sort of got rather kind of really excited and frustrated with Lord Denning's judgment. And I was saying to the students that this case is wrongly decided, in my opinion, anyway. And I think Denning's got this concept of a resulting trust, it dies and is born without any need for writing. And I had an overseas student who stood up and obviously must have done his reading before the session, which is quite rare, but sometimes it does happen, who disagreed with me. And he said, Sukhninder, I disagree. I think you fundamentally don't understand Lord Denning's judgment. And I thought that was a really brave thing for somebody to say and get up. And I sort of said, I really do disagree with him. And so we had this rather heated exchange. And we, at that time, at the institution where I was teaching at that time, had a in-house law journal. And I remember this student who completely sort of like was so convinced I got it wrong, that he actually wrote an article which was published in that journal, and now today is a senior lecturer at a university overseas. And I think that was a really memorable part of my teaching, the fact that, you know, one, he had the ability to disagree with me, but also the fact that he went on to write something, and having read his submission, I actually think he's probably got it right and I probably got it wrong. And the fact that he's now a senior lecturer, I like to feel that, you know, all of us law lecturers are contributing to, you know, students' journeys, their life journeys. I think that was a really memorable one for me, and I often share that with my students even today.
Wow. Thank you very much. Thank you. Well, if we don't have any more questions, I will probably close this session now. And I think we all got really valuable thoughts today to take with us today. We already have some feedback from participants coming in. I will share them with you. So thank you so much for everyone for joining and participating, and also a special thanks for Dora from Pearson for your hard work in the background. Of course, big thanks for Sukhninder for joining and sharing your knowledge today. It's been very much appreciated. We'll be in touch with everyone after this in the form of an email, actually 2 emails, one giving you information on how you can get in touch with Pearson for things like sample copy, demonstration of Revel, or a consultation if you'd like to speak to someone from Pearson. And of course, we would like to hear your feedback too. Then there will be a second email a bit later in about a week's time with a link to the blog with the recording and the slides of today's webinar. Thank you very much for everyone for attending, and have a lovely afternoon.
Thank you.